needs to happen is, the argument as I see it is this: Miss Choi, putting all the other things to one side, has an issue that the information provided is not concurrent with the reasons, and she takes issue with the merits of the decision. I infer from reading the admin review application, and Ms. Chu, you have this, do you?
Yes, I have.
I infer from that, putting the number of pages and the money to one side, that Ms. Choi is saying, having looked at the material, I don't agree that it reflects the decision or in the form of the decision. And so the issue is, until she did that, she wouldn't be able to form that view. I'm not deciding it now, I'm just setting something out.
Yes.
And as a result, there was no way she could have appealed within 40 working days, because she didn't get the documents till after 40 working days. So we need to set it down for a preliminary hearing. I propose to give leave to Ms. Choi to appear by telephone, because you're not likely to be in Australia, are you, in the near future, Ms. Choi?
Yeah, in the future, yes, I have to go soon.
To Australia?
Yeah, but not now. So
no, but when do you mean soon? When do you mean soon? How far ahead?
Excuse me?
When you say you're coming to Australia soon, how far ahead do you mean?
After I get some responses from other things.
Okay,
because,
so we're saying it mightn't be till the middle of the year or something.
Yeah.
Okay, so I think what we'd have to do is have a preliminary hearing with you appearing on the telephone. Ms. Chu, are there any? Well, first of all, Ms. Choi, is there any particular day that's not good for you?
No problem.
Okay.
Any as soon as possible, please.
Early as possible. Okay. What about you, Ms. Chu? I'd set a very brief timetable.
Probably any time from mid-March onwards for an actual hearing date would be.
Just
Mr. Chu, can you please attend in person next time?
Well, at the hearing, I think she would. I'm not sure why Ms. Chu's appearing by phone, but I just see there's an email confirming it, so I don't know the reason. Let me see. So this is just for the preliminary hearing about whether the time should be extended. All right?
Yep.
So let me have a look.
Senior Member McAteer.
Yes, Ms. Choi.
Instead of the time matter, can we decide is like notice of decision, 3 notice of decision, the separate issue. 27th of March, notice of decision 1. 4th of July, notice of decision 2.
Sorry, Ms. Choi, which isn't there only the supplemental decision becomes the decision, or the 2 decisions become the decision, don't they? I haven't got those decisions, so that's the first problem. But this decision of 25 March and 4th of July, they're the merits that you want to argue, aren't they?
No. My application has nothing to do with these decisions. That notice of decision is about $155 in accordance to the schedule.
No, hang on. Sorry, this 4th of July is the supplement. So this is why it would be really good if you sent the decisions in rather than the documents. So what I want to understand, Ms. Chu, maybe you can assist here.
Yes.
Do you have the 2 decisions in front of you?
Yes, I do.
Does the 4th of July just deal with the processing charge?
No, the 4th of July was actually an internal review of the decision of the 27th.
Okay, so the 4th of July, Ms. Chu, that's the decision under review.
Correct.
The March one falls away. Okay.
Correct.
So Ms. Choi, are you following this? If the tribunal could hear your matter today, it's only interested in the decision made on the 4th of July of last year, because that's the matter. That's what gave you the pages, the bundle. and that's the decision under review. The earlier decision becomes irrelevant. It's as though it was never made because of the second decision overtakes it. Does that make sense?
Senior member McAteer, actually, the respondent made the wrong name. Actually, the 27th of March, this notice of decision is not a notice of decision. It should be an acknowledgement letter. It's like a separate letter. It's not a notice of decision.
Okay. So just forgetting about that, can we agree that the decision under review is the 4th of July 2019 decision?
Sorry. Say again.
Can we agree that the decision you want the tribunal to review is the 4th of July decision, other than the...
No. I request the NCAT, as in my application, is the decision, notice of decision, released on 5th of December, year 2019.
But
not 4th of July.
Hang on. Was there a decision on the 5th of December? I thought there was just a bundle of documents handed over. Ms. Chu.
Yeah, 5th of December, the bundle of documents is a notice of decision.
Yeah, we're going around in circles. Ms. Chu, what happened on the 5th of December from the respondent's perspective?
We just released the information that was identified for release under the original notice of decision.
So Ms. Choi, the reason you need time extended is because the respondent says you're out of time and they won't acquiesce or roll over. They want the tribunal to decide it, okay? They say they made the decision on the 4th of July, but you didn't get the documents to the 5th of December because of the matters we've talked about. So the decision under review is the 4th of July decision. 2019 decision is decision under review.
Yeah, you are more experienced. I agree with you then. Yes, if you think it is right, yes, I agree with you. Go for it.
Okay, so it's the decision under review, and the respondent says your application of 13 Jan is out of time because it is more than 6 months.
No, not more than 6 months.
No, they say it is because they say the decision under review is the 4th of July. Okay. You say that you got the information on the 5th of December 2019.
Yes, I consider the notice of decision, the 5th of December.
Yeah, well,
notice of decision.
But what I think you mean when you say that is you read those documents in conjunction with the decision of the 4th of July and you formed a view. Is that fair enough?
No, I wouldn't say. The last decision was talking about the money matter.
You know, let's forget about the money. You got emails that had 849 pages.
Yeah.
When you opened those emails, you looked at those emails in conjunction with the decision of the 4th of July. Is that right?
Yes.
So that's your take on it. So the tribunal needs to decide that. Okay. So the earliest you're suggesting is at middle of March, Ms. Chu. Okay.
Yeah.
Let me just find a date. 17/16.
Senior member McAteer.
Yes, Ms. Chu.
Could you please mention senior member Moloney should be a member, because senior member Moloney is dealing with the similar case application.
Okay. But is he dealing with that on the papers, or have you got a hearing date?
Actually, senior member, I had a hearing is against the commissioner of police. The police sent disclosed my material to the.
Hang on, Ms. Choi. Who are the parties in the matter Mr. Maloney is doing with?
Police.
Right. Well, basically, I can't guarantee who'll hear it, but I wouldn't be requesting that he decide it because it's got different parties. But he might be the person who decides it. Are you saying that?
Do you know why? Because my issue is the police disclose my information to the Department of Justice. But Department of Justice released some information. The police said they didn't release. There is a difference between the information they released.
Okay.
So the senior member Mulroney is taking the consideration the disclosure by the police to UTS and UTS to among the UTS police and Department of Justice.
Okay.
So it's very interesting cases.
All right, Ms. Choi. My question is, do you or have you had a hearing for that, or is he dealing with it on the papers?
We already had a hearing, but I'm not sure about the other matter. Now it is the press conference.
So when you say, I need to know what matters you're talking about. Have you had a hearing before Senior Member Maloney?
Yes, I had one hearing, and then we may have another hearing.
Do you know when that's going to be?
Yes.
When?
There are two cases, two application numbers.
Right, but can you tell me when the other hearing before Senior Member Maloney is?
Yeah. With Senior Member Maloney, I had a hearing on 22nd of October, year 2019.
Right. Have you got another
And then
hearing?
the case number is 2019.
Hang on, before you give me the case number, no, Ms. Choi, I can't locate any of these things where I am. What I'm asking is, normally I would just set this matter down for hearing and it would be assigned to a member. But I can't have it assigned to Senior Member Maloney if he's not available. So I'm trying to work out whether there's a time when he's available. And my question to you remains, have you got another hearing before Senior Member Maloney about another GIPA matter?
Yes, I had.
Right, and when is that hearing?
22nd of October, year 2019.
No, that's last year. That's. Do you have in the future? Is there a hearing coming up? Not a hearing in the past. We can't go back in time and have it heard then.
No, the case conference. We have a case conference 17th of March. Okay. So no, we don't know yet. We have to decide if we are going to have another hearing, but definitely the senior member Mulroney is dealing with my GIPA matter among my information disclosed between UTS, police, and the Department of Justice.
All right.
And I wish the one member is dealing with my matter.
But this is just an extension of time matter. That's all we're dealing with.
Extension of time matter. All right. Okay, then it's different.
Okay, so look, what I'll do is I'll fix it for hearing, let me see, on the afternoon of the 20th of March?
Yeah, that should be fine.
2 o'clock?
Yes.
What time?
2 p.m. Sydney time.
Okay, 2 p.m., 20th of March. Mr. Chu, can you please attend in person on 20th of March? So I need to have a Korean interpreter.
All right, Korean interpreter.
Yes, hearing is very important.
All right. Now, Ms. Choi, if you want to put on your evidence as to why time should be extended, all right, I'll give you until, let's say, the end of February.
Senior member McAteer, firstly, could you please ask the respondent to divide the bundle, because the respondent released the whole 849 pages just bundle without the order of the sub points. For example, usually the public sector agency says from what page, from 1 page to 20 pages, this is subsection 1 and subsection 2, blah blah. But the respondent didn't say that, so it's very confusing to the criticize.
Well, the bundle I've got is paginated. Ms. Chu, the decision of 4th of July, does it have a schedule?
Yeah, they have a schedule.
Miss Choi, just wait a minute. Miss Choi, does it have a schedule?
It does have.
And does it refer to paginated pages or not?
No, not like that, because
No.
the nature of the request is such that it's in short, no, it's
Okay.
not perfectly
Look,
in that way.
Miss Choi, what we might do is we might wait until the tribunal decides whether you can bring your matter or not. All right?
Okay, I see. Okay,
all right.
no problem.
So look, I'm going to give applicant file and serve evidence subs. I'll type all this out. You'll get it as to why time should be extended. On or before 28th of February. So what day of the week's that?
By email, please. By email.
Okay. Where are we? February. It's a leap year, but 28th is Friday. Okay, on or before 28th. So when you say by email because you're overseas, is that why, Ms. Choi?
Yes, exactly.
Okay.
Yes.
By email. And I'll give the respondent 2 weeks after that,
Thank you.
which brings it to the 13th of March. And the date for hearing is the 20th. Okay.
30th of March, what the respondent
They're going to
have
put on their argument as to why you should not be given leave.
All right, can you please give me another chance for me, because I'm a non-English background person.
Yeah, sure.
So
I will. I'll
person-
explain it.
and
I'll
then can I send by the 17th?
Well, no, I'm going to give you to the 28th of February.
Yes, first 28th February, and then the respondent
By the
give
13th of March.
by when?
13th of
13th, and then I give another submission by 17th.
No, you don't need to do another submission. You can just come to the
Okay.
hearing, okay? It's
Okay,
only
okay.
on extending time, okay? Now, Ms. Choi,
Okay,
I
senior
can't...
member McAteer,
Yes?
can we go back to the
Yeah, we'll go back to that in a
the-
second. We'll go back to that in a second before we finish. What I
Okay,
just want to
thank
say
you.
is,
Thank you.
Ms. Choi, I can't tell you what your case should be, but you need to explain to the tribunal, as I've sort of understood it, that
Mhm.
you believe that
Yes.
the decision, the 4th of July decision, relates to the documents you received on the 5th of December. Okay? And
So sorry, one more again. I believe
no,
the decision
I
of
can't
7th
tell you what your case is, but what I see is that you've decided the 5th of December is a decision. It's not a decision, but it's the fruits of the decision. So you got the documents, you got the information from the decision much later, for reasons we don't
Yes.
need to go into. Okay? All right? Okay.
Yes.
Now, this issue about who's in the proceedings, Ms. Chu does not need leave. She tells me that she's appearing as the solicitor for the respondent. She also says she's an employee of the respondent. So under the Schedule 3 that I just took you to, she doesn't need leave. But what are you saying? You want her to file a notice of representation?
Yeah, okay. The senior member McAteer, you mentioned about the Schedule 3 administrative and equal opportunity
Yeah.
division of the NCAT Act
Yes.
year 2013.
Yes.
According to Part 5 Special Practice and Procedure 9, rights of representation and
Yes.
appear.
Yes.
1. And then you said despite Section 45, and then is the legal representative is the. However, that section number 2 and 3 and 4, that is a special practice and procedure. Is it like ombudsman or information commissioner or privacy commissioner? It has nothing to do with the Department of Justice. That is
hang
the
on,
my matter
stop.
is not.
Ms.
Yes.
Ms. Chu,
Yes.
so it's Part 5 of Schedule 3,
Yes.
Clause 9, Subclause 1. And Ms. Choi, are you listening? Part 5
Yes.
of Schedule 3, Clause 9, Subclause 1. Despite Section 45 of this Act, a party to proceedings, so let's say it's the Department of Justice or whatever it's called these days, okay, is entitled to be represented by an Australian legal practitioner without requiring leave of the tribunal. Okay? Full stop.
Yes. So my understanding is they don't need to seek leave.
Yeah. Does that make sense, Ms. Choi?
That one is the 9-1.
Yeah,
but
9-1, but no,
9-2-3-4.
you don't need to look at any of those. 9-1 applies.
Only 9-1 applies.
Yeah, because the department is a party. You've made them a party by naming them as a respondent. Okay?
All right. Okay. Then can I request the respondent to lodge the notice of decision
Yeah, that's
as
fine.
a notice of representation?
Notice of representation, yeah. Okay, so you can do that within 7 days, Ms. Chu?
Yes.
Yeah, okay. I'll just make a note.
But
to notice.
however, Senior Member McAteer, most of the public sector agency, they omit the Section 4 consent. So respondent should fill out the consent, Section 4 consent. That's
Section
my
4
request.
of Section 4 of what? What are we talking about now?
Yes, Section 4 consent in the notice of representation require the name and signature and the signature of the respondent, the person who decided to be interested in be against me, the proceeding. So the manager, name of the manager. So this person will be responsible for the whole proceeding.
Well, if you receive something through the registry and you say it's not in the correct form, what I suggest you do is you take it up with the registry in the first instance. Okay? All right. So if the registry sends you a notice of representation filed by any respondent, and you say that it's not compliant with the rules, you should raise that with the registrar. Okay?
And then also I raise the registrar as well.
Well, no.
Because
Okay.
the Senior Member McAteer, that is the main issue, the fundamental issue. The registry omitted that one.
Yeah, I'm not sure if I'm following you exactly there, but just let me go back a step. If anybody who is a representative in proceedings against you in NCAT files and serves a notice of representation, or any document that you say doesn't comply with the procedural rules, that's in the NCAT rules and the NCAT reg, then you should raise that with the divisional registrar. Okay? Raise it with them.
The regional registrar.
Divisional registrar.
Regional registrar.
If you still have a problem, by all means,
Yes,
raise it with the member hearing your case when that is. All right?
Okay.
Okay, so I'll send these orders out and you'll get those. And is there anything else, Ms. Chu, you want to say?
No, thank you.
Okay then, bye-bye.
Senior Member McAteer.
Yes.
Senior Member McAteer, could you please write down the respondent to attend the hearing in person? In other words, the hearing would be complicated because the interpreter and then the respondent and and everybody is on the phone.
Okay, well, the implication is, and I can't see leave, as I said, I saw a letter that referred to the respondent appearing by telephone. I don't know why that is. It's too late for me to inquire as to the reason for it from Ms. Chu, but I saw a letter which gives the number that I rang her on. And ordinarily, you must appear every time unless the tribunal gives you leave to appear by telephone. So, Ms. Chu,
Yes.
I am going to give you leave to appear by telephone at the hearing, but I'm going to make no order about the respondent, all right?
Sure.
So, sorry, Ms. Choi, Ms. Choi, I'm going to give you leave to appear by telephone at the hearing.
Okay,
Because
no
you're going to
problem.
be in Korea, but I'm not going to make any order about the respondent. So, if they don't turn up and they haven't got leave to appear by telephone, well then there'll be an issue, all right? But
Okay.
I hear what you say. If there's going to be a Korean interpreter here, it's much better that they're in the room with the other parties and then translating for you, all right? Ideally, they'd be sitting next to you.